Appeal Board to order. We'll do a quick round here. I'm in attendance, Julie Ryan Caputo, the chair. Sean Parker.
Present.
Terrence Bond.
Present.
Phil Cabucci.
Present.
Mike Loico.
Present.
I believe we knew that Mr. Ron Hogan was not going to join us today, and we're missing Whitney Kimmerling. Anyone else? Nope. Okay, great. Let's get started with announcements from Metro, and then we'll call our first case.
Good afternoon, ladies and gentlemen. The Metropolitan Short-Term Rental Board of Appeals is now in session for its regularly scheduled meeting of April 27, 2022. My name is Bonnell McBroom III. I am the Short-Term Rental Property Chief for the Metro Codes, and I will be presenting the cases to the board for review in today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silence as to not disrupt today's meeting. The procedure will be to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board in their rules provides the appellant in cases without opposition 5 minutes for the appellant to present their case. In contested cases, the board provides 10 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some of their allotted 10 minutes for rebuttal. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through all the cases set for the public today. After each case, the board will discuss and vote on that case. The board is vested with the power to act on these cases before us today under the following provisions as outlined in the Metropolitan Code, section 6.28.035. The code requires 4 members of the 7-member board to be present to constitute a quorum. The code also requires 4 affirmative votes to grant your application. The appellant for any aggrieved party, owner, may request a rehearing within 60 days of the public hearing. Further, the appellant or any aggrieved party, property owner may also appeal the board's decision to the Chancery Court within that same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you've applied. It should be noted that the permit must be obtained within 2 years for the board approval to remain valid. I submit that all cases have been filed in proper order. All appellants have been notified by certified mail and as required by the code. All affected property owners have been notified and the legal ad has been published in the Tennessean as required by the code. At this point, we'll see if we have any elected officials that wish to address the board. Seeing none. Chair Caputo, did you have any announcements?
Not a one.
All right. Our first case today is STR 2022-019. Is the appellant present? 2022-019, 1717 14th Avenue South. Is the appellant present?
Is there a Mr. Chen or Ms. Chen with us today? Yes, we're calling your case. Come on out.
Is there any opposition to this case? Seeing none. On December 21st of 2021, owner-occupied permit application was filed. On January 12th of 2022, the Administrative Services Officer, Madison Neal, reviewed the permit application. She noticed that the owner had an injunction on 1717B 14th Avenue South, an owner-occupied permit violation which started on May the 22nd of 2019. This means that a complaint was received claiming that this was not the short-term rental permit holder's principal residence. A case was opened and evidence was gathered and a warrant was requested and issued. The case was adjudicated in the environmental court and the appellant was found guilty of owner-occupied permit violation. Ms. Neal found that the appellant owns 2 other properties with injunctions on them. Ms. Neal forwarded the case to Inspector John Feltz, who confirmed that the evidence shows that 1717A 14th Avenue South is not the appellant's principal residence. The reasons given for the permit denial, bear with me one moment. The reasons given for the permit denial by Ms. Neal are as follows. The insurance policy submitted by the owner-occupied short-term rental permit application package contained the mailing address of 1368 Sweetwater Drive, Brentwood, Tennessee, 37207. The Williamson County Property Assessor's Office has the appellant on the deed as the owner of 1368 Sweetwater Drive, Brentwood, Tennessee, 37207. The mailing address for the property tax statement for 1717B 14th Avenue South is 1368 Sweetwater Drive, Brentwood, Tennessee, 37207. And Metro Nashville Property Assessor property record card for 1717B 14th Avenue South has the mailing address of 1368 Sweetwater Drive, Brentwood, Tennessee, 37207. Additionally, Inspector John Feltz found 2 vehicles for the appellant registered at 1368 Sweetwater Drive, Brentwood, Tennessee, 37207. It's a 2015 Mercedes-Benz CLA sedan and a 2017 Mercedes-Benz GLE 350 SUV. On March 4th of 2022, Ms. Neal mailed the appellant an official permit denial letter and sent an email as well.
Good. Anybody have any questions for Mr. McBroom before we hear from the appellant? Okay. Mr. Chen, if you could state your name, your home address for the record, and then tell us about your situation, and being quite mindful of the time that was described, okay?
My name is Kuren Chen. So I'm here to appeal the denial to my owner-occupied short-term rental permit application because I cannot agree the reason used by the court department officers. I submit my application with all information required for the owner-occupied short-term rental permit in December, as I said, December 2021, and I received last notice in March 2022, taking almost 3 months for completing my application review. During the time, I have never been asked to provide additional information. So why the review process takes so long time if all the information required has been provided? Specifically, I was told one time that my application was not found in the system, making me very frustrating. Why does the review process system look so messy? My application was denied only based on the sum of my mailing address found using my previous primary home, and it was then concluded that property at 1717A was not my primary home. Why? Is the mail address only condition to determine if the property is the primary home? Are there any laws saying that primary home can only be used for the mail addresses? Of course, I would like to thank the officer from the Metro Court Department because they let me know that my previous primary home still is used for some mail addresses and have given me the chance to make a correction on the accounts listed in the letter. However, I should say here that I have not noticed these mail address issues because I have used online and public service for almost all my accounts, including property tax, insurance, utility, and others. So that's the reason I haven't noticed the issues. Another question here is, who has the right to select the primary home, owner or government? As an owner, I should have right to determine which property is used as my primary home and make a change if needed. I'm wondering if any one of you here have had the experience that your primary home has to get approved by the local government if you have more than one property. In addition, also not required, I would like further confirm the property at 1717A, 14th Avenue South is my primary home, with providing more information as I submit to the board. One is the tax return for 2020 and 2021 clearly showed that the house 1717A was my primary home. Second, the mortgage application approved from the Bank of America indicate that the house at 1770A was purchased as primary resident properties. In short, I strongly believe the short-term rental permit application for my primary home at 1717A, 14th Avenue South has met all the requirements in terms of code for Nashville owner-occupied short-term rental permit. The denial from the court department based the mail address was wrong and should be changed. Hope you, the board member, can give me a fair judgment for my case. Thank you.
Mr. Chen, could you please state your name and your permanent address for the record? I don't think you did that at the top of your statement.
Okay. My name is Curran Chen, and my primary home is 1717A, 14th Avenue South.
Okay, very good. Thank you. Okay, questions?
Yes. Mr. Chen, you made reference to tax record showing that 1717A is your primary residence. I don't see a copy of that in our materials. Do you happen to have a copy of that?
I sent the email to the board as required. So why you didn't receive? I don't know. I don't understand.
And you didn't bring a copy with you?
It's in the email. I don't have the hard copy here.
Do you have your email on your phone?
Yes.
Could you pull it up?
While you're doing that, may I ask, too, when you made an application for 1717A,
Yeah.
did you also represent that as your
No.
permanent home?
This is the questions. As the code that require, there's two documents, is right? One is the driver license. One is I provided the bank statement. So I already provide all this. As I said, this additional information is not required. Actually, I don't need a presentation.
Terrific. Can I
right?
just go back to the question I asked you?
Sure.
The application has to be for an owner-occupied or a non-owner-occupied?
This is owner-occupied.
Can I finish my question? Thanks. So 1717A is an application you had applied for previously. And this came to the attention of those that were looking into it because there was already an injunction against you for 1717A for an application you made because that was applied for as an owner-occupied, was it not? And then it was determined that that was not your permanent address. So the fact that there was an injunction about 1717A was what caught the attention of those looking into this. So are you telling me you didn't apply for 1717A also as your owner-occupied primary address?
I never applied before. This is the first time I applied for 1717A.
So 1717A is what you say is your principal address.
Yes.
And that is the most recent refusal that we've had. But there was a complaint about 1717B, that there was an injunction.
3 years ago.
Right. But did
Because-
you not also claim that as your owner-occupied location? She noticed the owner had an injunction on 1717B, 14th Avenue South,
Yeah.
an owner-occupied permit violation.
Because when I apply, they give me the give me the permit.
But you had
I
claimed it
already
as,
had it, but I don't know if the policy changed or not. And then after 1 year, they said, no, you cannot apply. That one is my wife applied. It's not me.
Okay.
77B is not me. I'm not the applier. So this is completely wrong.
But you're the owner of that property.
Yes, I'm the owner, but it's not me apply, it's my wife apply.
Well, I don't think it's material in this case that
Yeah.
your wife applied, although you're both the owners, correct?
That 77B is not, why is not related to this? It actually is independent.
Well,
I applied now is 77A instead of 77B.
I think the issue that we're bringing up is, you can only have one primary residence,
Yes, so this is mine.
and your wife lives next door.
Huh?
And your wife lives next door?
No. My wife is not, my wife and me lived at 77A as well.
But she applied
So
for an
that's
owner.
why we quit the 77B. At that time, they said, no, it's okay. We quit. At that time, we just said, agree.
Well, you didn't quit before an injunction was issued, finding that that was not your primary residence and that you could not rightfully hold a license to run that as an owner-occupied Airbnb.
Yeah, that's why we quit it. Is right?
So, and we asked earlier about tax records that you emailed to the city to prove that this 1717A is your primary. Have you found those yet?
Oh, you want the email?
It is in the packet?
Yeah, it's.
Yeah, look
there's-
beyond.
Yeah, I don't know the
It's
system. Your
the
system
loose
is not
papers,
right.
And then there's a stapled one, and then was this one.
Okay. All
All
right.
like this.
Gotcha.
So, sir, what is the current status of the neighboring property then? What is that unoccupied? Is it rented? Did you sell it? 1717B?
77B? 77B right now, we have long-term rental,
Okay.
yeah.
and what is the status of 1368 Sweetwater Drive, Brentwood, Tennessee?
That's my second home.
That's your second home?
Yeah.
But that's where you have your two Mercedes-Benz 2015 and 2017 registered?
Yes.
So if we went in the parking lot right now, your car has Williamson County on it?
Yes.
Okay.
So your driver's license also says Williamson County?
No, driver license is Nashville.
Okay.
I have the copy for the short-term rental application.
Okay.
Yeah. 1778 for my driver license.
And there were also some records shared with us for 1600 Electric Avenue. What's that property?
That is a long-term rental right now. Yeah.
So, if I remember correctly, and staff can correct me if I'm wrong, to be in a two-unit HPR and get even a non-owner occupied permit, you've got to own both and live in one.
And they can both be owner occupied?
I don't believe so.
Only one.
Only
I don't
one.
know if this is an HPR, but that may make a difference.
Sure.
Verify that for you.
Any other questions for Mr. Chen? Do we want to give Ms. Chen another, oh, we have the records, sorry, that's what we were waiting on. Okay, yeah. I think we saw those on the email earlier, too. Mr. McBroom, is that something we need to be aware of on the screen? Oh, okay. Okay. Let's keep the public hearing open just another couple minutes in case Mr. McBroom comes across any pertinent information that we want to talk to Mr. Chen about.
Another question for staff. It's noted here that the appellant owns 2 other properties with injunctions on them. That's in addition to the 1717B 14th Avenue. And if so, is one of those properties the Electric Avenue property that was mentioned? And what's the nature of those 2 injunctions, if you have that, those 2 additional injunctions, if you have that information?
The injunction for 1600, which is still owned by Mr. Chen and his wife, is for advertising and operating with an expired permit.
I'm sorry, for 1600 Electric Avenue, it was advertising and, okay.
And 1717B, as noted, was for owner-occupied permit violation. I do not know if 1441 14th Avenue South has a current permit.
So are there a total of 2 properties with injunctions on them or 3 properties with injunctions on them?
It reads like there are 2 other.
Yes, there are.
A and B are mentioned in the narrative, and then Ms. Neal found that the appellant owns 2 other properties with injunctions on them. So Electric Avenue we know about, and then maybe 1441 14th?
Yes, but I don't have the documentation on that, and unfortunately, I do not have internet connection here to
Okay.
verify.
Mr. Chen, are you aware of a injunction you have against the property at 1441 14th Avenue South?
Yeah, that one is also because, first time I got the applications, the permit, and then in the same case as the 1770B, in the letter, they said, no, you cannot get one more owner-occupied permit. So that's why at that time, they leave the short-term rental permit for 16,000 Electric Avenues. And then I quit the other 2 properties, 1770B, my wife, and for me, I quit the 1441. Okay, so that case is very clear. But unfortunately, for 16,000, I was over the time to renew. So that's why at that time, I was trying to renew. They said, no, you have missed the time. I didn't receive any notice renew. I missed the new time. Eventually, I have to quit that as well. So that's why right now, I try to apply for 1770A. Yeah, but at that time, when I quit the 1600, at that time, in the court, they said, you can apply for others. That's why, I try to,
Okay.
yeah.
Mr. Chen, I have a question about the vehicles that are registered to the Sweetwater address in Brentwood. When were those purchased? When were those, the 2 vehicles, the 2 Mercedes?
The
when were those?
2-vehicle Mercedes is 2017.
2017?
Yeah.
And they were both purchased in 2017?
You mean, you talk about which one?
Both vehicles. There's a 2015 Mercedes and a 2017 Mercedes. What years were those purchased?
2015 Mercedes.
Right.
Huh?
The sedan was the sedan is a 2015.
Yeah, that one is my daughter, yeah.
Oh, that's your daughter's?
Yeah, my
Okay,
daughter,
I got you.
Yeah.
And when was that purchased?
I think probably also a couple years ago. I don't remember at exact time. Yeah.
So after the time, looking at your mortgage application, it looks like that's dated 2015, correct?
That car is 2015, but maybe the purchase
your
year
mortgage
is not.
application was
That's the
2015.
second, yeah.
Mortgage application was 2015, correct?
Yes, for this 1717A, yes.
Okay, so you have 2 cars that, if I'm understanding you correctly, were purchased after the fact, and they are, the address associated with them is the Sweetwater address. Why would that be the case?
As I said, we purchased 1770A because at that time, my daughter in the high school, the Hengfog, the downtown the high school, and then she went to the college, Vanderbilt, so now she's still there. So we leave 1770A because we can help, my daughter very easily. But we still keep, the 1368, yeah, as my second home, yeah.
Okay. So does that mean that when you give your insurance company information for the cars and they write you a policy and they set a rate based on where in Nashville or Williamson County your car is located, they have inaccurate information because they think that your primary address is in Sweetwater Drive in Brentwood and not Nashville, where the rates would likely differ?
Yeah, actually, this is like I didn't know these issues like seriously. I was just keep renew. I actually, as I said, I was thank the code department give me chance to make a corrections right now.
Okay.
I just noticed this kind of manner because as you guys know right now, most things online, like a property tax, all these things. I never care about where they send the mail, the physical address. I'm not noticed too much. That's why I think I was thank that this chance given to me.
Thank you.
Any other questions? Okay. We're going to consider the public hearing closed, which means only if we reopen the public hearing and ask you additional questions, Mr. Chen, will you have another opportunity to speak. So for now, we are going to talk amongst ourselves and come to a decision on how to handle this case. You're free to stay there, or you can return to your chair.
Okay. So when I should.
Excuse me, I just said we have the public hearing closed, so we can't have any more conversation. You're free to stay at that table if you like. If we reopen the public hearing, you'll have another opportunity to speak with us, okay?
Okay.
I'm personally not seeing enough evidence to go against staff here.
And yeah.
I think staff had ample information to act. And I mean, there's certainly been some interesting questions posed about who's to say what's one's primary address. I think, fine, good question to ask, but I think we know this isn't his primary address.
There's some case law that the zoning administrator likes to quote on that.
Yeah. I was about to say there definitely legal tests for determining what's your domicile.
Yeah.
For certain purposes. So I think that obviously putting it on a tax form is compelling, but it just seems like there's so much other information that doesn't agree with that representation, and I won't go any further into the potential consequences of designating somewhere as your primary residence when it's not.
And stepping up to the plate 4 times now to claim different places as your owner-occupied locale, some simultaneously. I don't think we're in a position to offer any relief, right? So I guess we do need to determine what.
So
Move that the zoning administrator did not err.
Yep.
Okay, and that's it?
Absolutely.
Because there is no permit to renew or.
Yeah.
Yeah, whether or not the zoning administration made a decision in error or not is pretty much.
Is all we're to do.
So
Okay.
I'll move that the zoning administrator did not err in this case.
And I'll second.
Okay, let's see a show of hands. Okay, the ayes have it. There's Mr. Chen. Okay, Mr. Chen, I'm sorry, but we have decided that the zoning administrator was correct in his or her decision. So thanks so much for your time today, and we appreciate you coming in. We're supporting the decision made by the zoning administrator. We feel that this decision was not made in error, which is the only thing that you brought us today was that the only thing we could do today was determine whether or not an error was made. We don't believe an error was made. So we really appreciate your time.
I cannot make like
I know you disagree with us.
primary has to be.
I know. We're not going to continue to debate it. As I said, the public hearing is closed. We've heard all of the evidence. We've read everything you shared with us, and we've discussed it amongst ourselves.
Sir,
So,
your remaining
thanks.
appeal rights were explained at the
Thanks.
beginning of the
I cannot,
meeting.
make selection for the primary home.
You have remaining appeal rights if you wish to exercise them. Apologies that you didn't get the outcome you wished for.
Okay, Mr. McBroom, the next case.
If I may interrupt, at the beginning of our agenda, the printed agenda is case STR 2022-18. This is the Ramsey Street case. Just in case, was that one not heard first for a
That
reason?
was deferred.
Okay, so anybody that's here for the Ramsey Street, if you happen to be here in relation to that case has been deferred.
That is, the appellant was Mr. Leland Smith. Okay, great. Okay. So we're on to case
Looks familiar to me.
2022-21, is that correct?
That's correct.
Okay.
Glad you called that out so they weren't sitting there for.
Yeah, seriously.
This is counsel for this case, Mr. Sean Henry, and his client has not arrived. He's asking to defer. You have the option to, if counsel thinks that his client will arrive, that we could move the case to the end of the docket. That's for your decision.
Absolutely.
He's not going to be here. He called me during.
Oh.
During this meeting, so he can't make it. I don't know what's behind that. So we'd like to defer that to next meeting, and we'll be here to make our presentation.
Is there anybody here?
Yeah,
opposing the case?
has anyone appeared in to object to, and I'm sorry, this is the Ronnie Kelly Britt Place appeal, is that correct?
We do have opposition present.
We do have opposition present. So I'm so sorry that you've taken the time and found your way here this afternoon, but it looks like we're going to defer this case until the next hearing, even if that's, I was about to say if that's okay with you, but even if it's not, it looks like we are going to defer it. Okay, thank you so much. Thanks, counsel, appreciate it.
Hate it. Okay, it's 4 people that sat here for cases.
I know, I feel terrible. Shoot. I wasn't looking at the agenda, that's terrible. Okay, well then, we're moving swiftly along to 2022-22. Chester Avenue?
No, this would be
23.
Was,
Why are we?
I thought Britt Place was Ronnie Kelly.
22 is also deferred,
Okay,
and the last case on the docket is 2022-23, which has
right.
not been deferred.
okay. Jonathan Weaver and the Jonathan Weaver Revocable Trust on Normandy Place. Come on up.
Is there opposition present for this case, 3614 Normandy Place North? This is governed by Bill 2017-608. The effective date was February the 2nd of 2018, and it gives the board discretion to reduce the one-year wait period. On May the 10th of 2015, Airbnb website ad was posted on, during 2015, there were 3 documented stays. 2017 had 1. February the 10th of 2018, a notice of violation was sent for no STRP permit. On August the 10th of 2018, the Airbnb website was removed. On August the 8th of 2018, the owner-occupied permit application was initiated. On August the 18th, that Airbnb website ad was reposted. On October the 30th of 2018, the permit was issued. It was renewed on October the 8th of 2019, and again on October the 15th of 2020. February 24th of 2021, the property was quitclaim deeded to Jonathan Weaver Revocable Trust. And 17.16.250.E.4.K reads, a short-term rental permit shall not be transferred or assigned to another individual, person, entity, or address, and nor shall the permit authorize any person other than the person named therein to operate short-term rental on the property. March the 7th, throughout the following months, there were numerous stays. On October the 30th, 2021, the permit would have expired had it not already been canceled by operation of law on February 24th, 2021. November 2021, renewal documents and a check were received by the Codes Department, and they were returned because the permit was canceled and could not be renewed. On January the 10th of 2022, the address was on a monthly list of properties advertising and operating a short-term rental permit provided by Metro Government's compliance contractor, Granicus Host Compliance, the follow-up investigation. A notice of violation was sent by Inspector John Feltz for advertising and operating without a permit. On January the 28th, 2022, the Airbnb website was removed, and there were a total of 50 documented stays after the ownership change. On February the 10th, 2022, this date is the end for the remedial time period for the notice of violation. On April the 12th of 2022, Inspector John Phelps received an email complaint that the property was continuing to be rented as a short-term rental property, and there were out-of-town guests there on that date. On April the 13th of 2022, Inspector Phelps conducted a site visit, and the following is his report. On April the 12th of 2022, I received an email concerning 3614 Normandy Place North, and how the property was consistently being short-term rented despite not having a valid permit. The next day on April the 13th of 2022, I went to the location to investigate the complaint in the email. On April the 13th, 2022, at roughly 12:40 p.m., a neighbor approached me as I was placing a stop work order on the door at 3614 Normandy Place North. The neighbor told me that they were aware that the property should not be operating a short-term rental at this time, and they know about the appeal hearing. The neighbor proceeded to tell Mr. Phelps that the property owner had never stopped short-term renting, even though they were not supposed to. And Mr. Phelps was told that there are different people in and out of the house almost every weekend. And the neighbor that was speaking with Mr. Phelps is in direct sight line of the property and watches different people come and go all of the time since the abate period ended on February the 10th of 2022. As Mr. Phelps was there, a car from out of town was there with Wisconsin license plates, and he proceeded to put the stop work order on the door. Talked with the neighbor and left. Came back 2 days later, and the stop work order had been removed without permission, which is a violation of the code, and that is submitted by John David Feltz, short-term rental inspector, Metro Codes, Nashville, Tennessee, Davidson County. There's photo evidence in your packet concerning the site visit. An additional concern is this was an owner-occupied permit. However, there's considerable documentation that indicates that the appellant lives at 72 Ravenwood Drive, Jackson, Tennessee, and you have documentation backing that up consisting of a medical license, mailing address for the property tax bills for 3614 Normandy Place North is 72 Ravenwood Drive, Jackson, Tennessee, 38305. The quitclaim deed for 3614 Normandy Place North that canceled the permit for the change of ownership has the mailing address as 72 Ravenwood Drive, Jackson, Tennessee, 38305. And Madison County property records for 72 Ravenwood Drive, Jackson, Tennessee list the property ownership as Weaver Jonathan Bernard, Jonathan Weaver Revocable Trust, owner occupied. The application for the not owner-occupied STR permit at 2910 Felicia Street, number 4, which is owned by Jonathan Weaver Revocable Trust, has the owner contact information as Jonathan Weaver, 72 Ravenwood Drive, Jackson, Tennessee, 38305. Now, the decision before the board today is whether or not to lessen the time period because of the expired permit. However, in full disclosure, we wanted to make you aware of everything, all the evidence that it's around the case. But it's basically for operating with a canceled permit due to ownership change.
Great. Any questions for staff before we get started? No?
I do have a question. So I'm trying to remember the history of what governs what constitutes an ownership change. I know that Metro at one point defined it, and then I believe there was state legislation that perhaps attempted to modify as it relates to some kinds of trusts and whatnot, but actually did the opposite of that. And they were trying to go back and clean it up this year, but the bill got messy. And can you tell me a little bit about what governs, does state law govern what constitutes a transfer of ownership, or does Metro Code define that?
The state law governs, but it basically is stated the way that the Metro ordinance is, so there's no variation. You are correct. There was an attempt to make a change to that in this year's legislative session for the state legislature, but that legislation never came forth. It was tabled or deferred, but in any event, it was not changed.
Thank you.
We had a discussion last meeting about this very issue.
Yeah. That was a little cleaner.
It was.
Yeah. All right, so we're good? So, Dr. Weaver, I presume, if you could state your name and your address for the record, and then tell us about your situation.
Jonathan Weaver, and the address is 3614 Normandy Place, North Nashville, Tennessee, 37209.
I understand that's the address we're talking about, your address. Are you telling us that's your address also?
Yes.
Okay, very good. Thanks. Go ahead.
Yep, so I'll be respectful of the 5 minutes. Thank you again for the time to meet. Yes, I'll start again. The main reason here is for lessening of the 1 year. I don't dispute what Mr. Feltz and Mr. Osborne has communicated, but my effort is to provide the clarification, and the main thing is, as you alluded to, the change in ownership. So the last 3 years, I've owned and occupied that property and rented out as a short-term rental and had no problems or issues with the law the last 3 years. However, in my personal finances, I've had discussions with my lawyer and personal financial advisor recommended having a trust for my assets, and this had nothing to do with the short-term rental. And I knew that there could be issues and problems with getting a trust and putting properties in them, and that could affect my permit. I had many discussions with my lawyer before February 2021 with doing this, and he advised that if the trust is still in your same name and the house is in my same name and there's nothing different, he did not think there would be any problems or issues with any change in ownership and with the permit. I advised him to look into Tennessee law to make sure this was the case. I looked on the website, and it's very clear that you guys have posted that any trust, and it's very vague in general, but any change in trust is a change in ownership. So I advised my lawyer to not put this house into a trust, to keep it as my name as owner occupied, and everything would be fine, and I would not have to be present here today. There would be no issues. However, my lawyer decided to, back when we made the trust, he, in his error, placed the house in the trust. I was unaware of this, and this was completed in February 2021. There is a letter from my lawyer explaining what he did and that it was his error. It should be in the packet. I apologize if the packet is long with lots of information. There is a letter, and that basically, in summary, the letter, he states that it was in his error. He should not have put the home in the trust, and he advocates to basically renew the permit, and also that the house was moved back into my name. So the house has been moved out of the trust, and it has been back into my name. So since then, that happened. I was unaware that it happened, that error. And so I agree with what Mr. McGrew mentioned was in February 24th, it changed ownership, and it did. I don't dispute that. And then it was rented. And if it changed, and that made the permit, in effect, non-operable. And I don't disagree with that. During that whole time, from February 2021 until January, I was unaware of that. And I specifically started to become aware of that in October, when I paid and submitted my check to renew my fees, my $313. It did not, the check never cleared, and in fact, it was mailed back to me, as Mr. McGroom stated. That check was mailed back to me, so then I emailed 5 times the short-term rental email to try to figure out what was going on. At the same time, I received a letter stating that the policy of renewing permits has changed to now it's online only, and I don't mail in a check. So I thought that could have been the problem. Maybe there was some overlap. So I emailed 5 times, and that should be included in the packet, several email attempts to figure out what was going on, because I want to be compliant and I want to pay my fee to continue as I have been the last 3 years. So I received no information. I even contacted David Freibut, who I've had a good relationship and working with, and he responded quickly to me. And he stated, just be patient, it may take some time for the permit to renew. So during that time from February 2021 until January 2022, I was completely unaware that the house was put in change to the trust. I was then made aware of it in January when I got notice of operating without a permit. This was a major problem. I had then contacted my lawyer about this. I emailed David Freibut about this, and this is all in there as well, to try to get it sorted out as soon as possible, okay? Because I don't disagree with that. If that's the case, then it was in error. That's not disputed. So I then talked to my lawyer about it, got his information, made him change it back into my name, so it's not in the trust. I made sure that was crystal clear with the documentation of nashville.gov with the website. And then I also then made sure that I emailed Mr. Osborne and Freibut to then come here to this meeting, because I don't oppose Mr. Osborne's decision for the year, but I thought that this extraneous circumstance was worth it to take to the board to describe, because my past experience was you guys take everything under consideration and seem to be relatively reasonable with most cases. So,
Sorry, Dr. Weaver, that's your time. Okay. But I'm sure people have questions for you, so probably get an opportunity to finish your thought. Who has questions for Dr. Weaver?
Mike, you can start us off if you'd like. I do have one, though.
I would like to ask about the, if you could tell us about the 72 Ravenwood property, who lives there? If you explain that to us.
yes, sir, of course, no problem. So my driver's license, I have 3614 Normandy. That's my primary address. I've been employed the last 4.5 years in Jackson, Tennessee. I was a physician at Jackson Madison County Hospital. So I was commuting several times back and forth, many times, and it became too much. So I did purchase a home in Jackson, Tennessee. So that is my home there. Now, renting the house out at 3614 Normandy Place, getting mail has become a problem over the last 2.5 years. I've had guests when they stay there, when I rent it out, and they ship mail, and they get Amazon products to the house, and they have stolen mail or left mail that was supposed to be for me and very important mail. So I changed my mailing address to 72 Ravenwood, and that house is used so I don't have to drive back and commute from working on call at the hospital all the way back to Nashville. Does that suffice, or I can go into further detail if you need?
Paints a clear picture, thank you.
So my question is, at what point, I'm not super clear on when you became aware that the permit was canceled. When did you first become aware that you were operating with a canceled permit?
January, about the middle of January, when I checked the mailbox at 3614, and I saw a letter there. I also had a letter mailed to me at 72 Ravenwood. That was in about the middle of January. That was the first time I was made aware. And then, as Mr. McGrew mentioned, that then I stopped then the active listing on Airbnb at that point, when I realized that, yes.
And these stays, like when the inspector went by just a couple days ago or 2 weeks ago, were those stays that I guess they were already booked before you removed the ad, or what was the status?
Yes.
With
So
those?
in addition to the Airbnb, the VRBO platform, I have a specific individual website. So that website, people can go on and see and look at properties and contact me directly and stay at the home. And so when I looked on the government website, if I'm not booking through a platform of Airbnb, VRBO, or Home Our Way, so that's where they contacted me to stay at the house.
It's advertising. I mean, that's still advertising a short-term rental if it's not through one of the big-name platforms.
Yes. So then, if that's the case, I don't disagree. Then if that still constitutes advertising, I don't disagree with that. That's what I was.
And lastly, the stop work order that was posted. Are you aware of how that got removed? Did you remove that?
No, I'm not aware of how that got removed.
Okay.
Mr. Weaver, so this is a very interesting set of facts. And the first question I have for you is your license to practice medicine, or your registration with the Board of Medical Examiners for the state of Tennessee. I'm sure it's very much the case. I'm a lawyer, and whenever I have a change of address, I have to notify the board within a certain number of days. When you bought the house in Jackson, did you change your address with the Did you change your address with the Board of Medical Examiners to the 72 Ravenwood?
Yes, with the Board of Medical Examiners, for mail purposes, yes, it has changed to 72 Ravenwood, correct.
Okay.
Correct.
That's where you receive all your notices.
Correct.
I gotcha. You said that you discovered in January of 2022 that there had been a mistake with the property being deeded to the trust.
Yes, correct.
Okay. So I'm looking at the document deeding the property back out of the trust, and it is dated April the 6th. And the original document deeding it to the trust was prepared in 2021. And this is big of your attorney to actually admit to this body that they committed malpractice when causing you to lose significant financial opportunity and costing you a permit for an income-generating property. And yet they waited from January when you discovered, and you guys were having conversations all the while, they waited from then until April 6th to actually deed the property back. Can you explain exactly why they would let an error of that magnitude continue to hang, knowing all the while that you were continuing to amass violations of the Nashville City Code relative to the operation of a short-term rental permit? I'm very confused by that.
Yes. Well, a part of me agrees with you a lot because I have had heated conversations with my lawyer. I agree with you in that. And so I have been talking with him for 2.5 months to get that done. I would prefer that. I wanted to get that transferred over by the end of January was my preference. And actually, he sent several emails to Mr. Osborne and Mr. Freibutz on the end of January telling him of the situation to see if he could just revert it back into the ownership and maintain the permit. So there wouldn't have been any change. But I don't think he understands how the practice is. You can't easily just change something like that. And so I have been pleading with him over 2.5 months and with my financial advisor. And I copied several emails. Again, it's a packet to make sure that all that information is there. And but in that case, to find another lawyer was a bit cumbersome and expensive. So I wish he was here sitting next to me to defend himself, but it is.
He should be.
And as well, you know this, but exactly. So I was on him as much as I can, but he was involved with my trust, and so I thought that to have uniformity in terms of communication,
right,
he should be the one that writes the letter saying it was in my error who committed that. But the delay, I cannot give you a good, solid, truthful reason because I don't know. I can tell you that I made it crystal clear to him that, as you said, I've lost out on revenue and, had violations of stay, which I don't refute. And so that's the best answer I can give you. I wish he could provide evidence, but his evidence is based in that letter, and that's all I can provide. Yes.
Understood. And I have another question. So there's a little tension for me between some things that you said earlier. You mentioned that there was lack of clarity in the law, and you were aware that there was consideration for putting this property into a trust at one point because you'd asked your erstwhile counsel to research provisions of law and give you an answer as to whether or not this would impact the status of your permit. So there was awareness on that part. So I'm not really understanding how you could contemplate placing it in the trust, and then I guess there was a decision not to, and they did it anyway over your express instructions not to?
Yeah, I can. Yep. Totally. I easily clarify. Yes, we talked about that because of the risk of putting all major assets basically into the trust to avoid probate. Okay, for
right,
death for family,
right,
obviously, you know.
Right.
But yes, there was conversation from my financial advisor and my lawyer, both advising me to do that, and they both said that there wouldn't be any problem. I was the one that confronted my counsel, my financial advisor, and the lawyer who stated there, and I said, they're very particular about this. I've been doing this for 3 years here in Nashville.
Right.
I'm not an expert on it, but I know you have to be very careful what you do.
Right.
And so I advised them to not do this.
Okay.
And they pushed back and said, I think we can if it's under your name, and then you have all the benefit of being in a trust. I said no. I didn't want that to happen. That was back before February 2021.
Wow.
And that is why I made sure I had that letter from my lawyer to confirm that, to provide evidence.
Right. But as you said, you've been doing this a while, and you had a good relationship with David, and obviously you know the email address for STR, but you didn't reach out and say, hey, I'm putting this in a trust. Correct me if I'm wrong. This is no problem.
Right.
You didn't do that.
No, because I did not want it in the trust. That's the point. I did not ever want it. It was placed in the trust in error by my lawyer. I agree with you. I did not reach out because I didn't want it in the trust in the first place.
Any other questions? So I'm sorry, I do have a question of my own. So the check was returned to you, but did you ever get, besides the stop work order, did you get a letter saying, I think we do have it, right? Letter saying, okay, the letter I have here is for your appeal. You got a stop work order on the door. Did you get a letter saying you're ineligible because you were
Yes.
operating without a permit?
Yes, in January, that's correct. In
Okay.
January I did, and that's when the advertisement and was taken down, yes.
Okay.
Correct.
But the letter said, because it's a form letter, so we've all seen it, it said you need to cease operations and advertise it. Now, you just told us you thought maybe having a private website got around that, but you know that you're operating, right? The website in and of itself was just a means to operate. So you chose to continue to operate even though you'd received a letter saying that you were to cease operation.
Yes, yes. I looked at the definition of short-term. I believe it's less than 30 days for a stay. And then on the Nashville.gov website, it describes using a platform. But yes, I don't dispute that. I had a just personal website that people could go to and send contact information to me, and then send me payment via Venmo, PayPal, any methods. Obviously, there's no legal protection or liability by doing this, okay? And it's very, very frowned upon. It's not a good thing to do. But originally, that website was to provide extra marketing when I have working legal permits. But what you stated is correct, yes.
Okay. And just to confirm, when Mr. Feltz came out, when John Feltz came out on April 13th, and there was a guest there from Wisconsin, that was a short-term rental guest, right, that you booked through your own personal website?
Correct.
Okay.
Correct, yes, it was, yes.
Any other questions?
None for me.
Any other questions?
Dr. Weaver, this might have been reviewed already, but when was the property brought back into your personal name?
April 6th.
Okay.
So then why in an email to Metro did you say that that the property was already brought back?
Because I had.
February?
Yeah, sorry. Yes, because in February, I had contacted my lawyer, and he stated that he would rush to do it by the end of January to complete it. So that may be, on my part, a premature email message stating that, because I was going off the assumption that my lawyer had it done in time, because when he sent me the email, he will quickly move it, noting that it is a time-sensitive nature. But however, that would have been a premature email sent on my part, because I wouldn't have true verification of that.
Thank you.
Yes, sir.
Any other questions? No? Okay, Dr. Weaver, we're going to consider the public hearing closed. So that means we're going to discuss this amongst ourselves. When and only if and only when we reopen the public hearing, will there be another opportunity to discuss? It's entirely possible a question might come up that we do that, but otherwise we're going to consider our conversations with you complete. Okay? Thank you very much for your time. Okay.
Yeah, I think we've seen a couple of cases now involving these, what constitutes a transfer, et cetera. I mean, I don't think that there was any error on staff's part in determining that the property was transferred as defined by state law. This body's job is not really to debate the law. And, as far as our ability to exercise leniency, I mean, I always like to see proactive steps taken on part of an appellant once they're aware, so that we're not tying up staff, going to do investigations, posting stop work orders, going to see if the stop work order is still there. At that point, that's sort of a strain on the city's resources, and that makes it difficult for me to see the case for a reduction here. So I think it is unfortunate circumstances, and maybe that does need to be revisited, what constitutes a transfer. But the law is the law, and then I'm not seeing I'm not seeing the type of activity of, canceling reservations, of making sure that no advertising or operating is happening
Right.
ahead of the appeal. I mean, we're talking about 2 weeks ago,
Yeah.
I'm not completely unsympathetic to the appellant, but this is a terrible set of facts. And I'm actually just very, very surprised at counsel in this case.
Yeah.
Extremely surprised. So I can't find any warrant for a reduction in the waiting period either.
I do have a question.
Sure.
We're talking this year waiting period. What's the start date that we're working around?
Well,
Is it-
I think,
We would have to determine that.
yeah, so along those lines, we had a case recently, I think Sean wasn't here for, but we had a case recently that the primary fact was similar. It was a trust that was created, and the owner was the owner and his wife were the only members of the trust. It didn't strike me, it didn't strike any of us, it was that it violated the spirit of what was attempted in like 608 to try to keep it from, just being like Airbnbs being sold as Airbnbs or short-term rentals being sold as short-term rentals. So I am sympathetic about that. I'll reserve comment about counsel's behavior on this matter, but we've all had appellants tell us, oh, my lawyer screwed up, my accountant screwed up, my manager, my property manager screwed up, and unfortunately, it's always the owner's responsibility, right? So malpractice or not, this comes down to the owner, and there was a stop work order, there was a letter. You don't.
A notice of violation.
You don't find ways to work around it. Like, I'm going to do my own. I'll do my own website. And, when the hearing date has already been set, have short-term rental guests at your house. I think that is what strikes me. It really isn't the issue about their trust, because I think that's very understandable.
Right.
It's the I'm going to find a way to just work around it. So to me, Mr. Phelps being out there on the 13th and having to take the time, when there are so many properties to deal with, to take the time to observe that the stop work order had been removed, to observe there's a Wisconsin plate there, to have to take the time to discuss with neighbors, like it's never stopped. I appreciate Dr. Weaver's candor, but I don't think Metro appreciates having to waste resources unnecessarily. So to me, the last violation was April 13th.
I agree.
And I'm open to debate, discussion, if people think that's harsh.
I think it's reasonable under the circumstances. It's not what I want the decision to be, obviously, but the facts are what they are.
Yeah.
And I think that's the date. I agree that that's the date.
I go back to this email, though, that he's sent, that Dr. Weaver sent back in February.
Okay.
To the STR, or to Mr. Osborne.
Saying that it had already been reverted.
That it had already been done.
Yeah.
And I think that we've already seen multiple instances where this lawyer has made really terrible decisions, has delayed, has blocked, has said that he would do things and them not being done. That really bugs me in the same way. I would almost say that if Dr. Weaver here is saying that on the 21st of February he thought that the trust was being done, or his property was being brought back into his name and not through a trust, and the change actually didn't happen until April 6th. I would say that maybe February is a time frame that
I
I'm willing
would
to see.
agree with you there. If the taking the property within the trust to outside was determinative in this case.
Yeah.
But it didn't really change
Right.
anything. The permit's already canceled.
Correct.
There's no other
Yep.
remedial action. There wasn't a new permit filed saying, hey, here's confirmation, here's a new copy of the deed. If I had seen any of those things happen around the same time, I would totally agree. But since none of that happened and the taking it out of the trust was moot at that point because there's no permit, they're trying to reestablish and there still stays happening.
And there has to be like a closing or a quitclaim or something in order to do that.
Right,
So Dr.
right.
Weaver knew it hadn't happened, or should have known it hadn't happened,
point.
because he hadn't, you
He
know.
hadn't signed it.
Yeah, nothing had been signed. That's another thing. There was nothing had happened to actually indicate that there was a change in legal
I'm out.
status
I'm
as
out.
to the
We're
property.
done.
So,
We're
yeah.
good. Okay,
Yeah.
thanks.
It's a hard one. It's a
It's a hard
one.
one. I mean,
Sort of-
if it had been, I
Yeah.
think, Terrence said it correctly, if it had been like, oh my goodness, this is terrible, let's cancel all the plans, oh gosh, this is gonna stink, maybe we'd be making a different decision. But I think continuing to operate in a, kind of roundabout fashion, trying to skirt the requirements of the ordinances, I think that's what puts me on April 13th as the start date for the 1 year.
Yep.
Mike, what do you think? All right. So I'm going to make a motion that we will be offering no relief in this case, that the start date for the waiting period begins at the date of the last violation, which is April 13th of 2022.
And yes, we'll be eligible 1 year from that date.
Okay. So do I hear a second?
Second.
And let's see a show of hands. Okay. The motion carries. So, Dr. Weaver, your waiting period begins on the date of your last violation, which was April 13th. So 1 year from that date, you can reapply. Thanks so much for your time today. We really appreciate it.
Thank you.
Okay. I think that's our last case, yeah? Very good. Let's consider the short-term rental hearing closed.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.